Welcome back, ladies and gentlemen. This is Law 254, your favorite legal show that seeks to demystify the law, give you useful tips and guidance on how you can interact with the law on a day-to-day basis, basically putting the law in your hands. My name is Wakili Kitty. I'm an advocate at the High Court, and today we want to talk about an issue that has been gaining a lot of publicity in the past 2 weeks, and that is the BBI, Building Bridges Initiative. A lot of Kenyans out there do not know what happened. All they know is that there was momentum, and all of a sudden the BBI train came screeching because of a few judges and the law. So we want to discuss what law made that happen. And joined with me is Waithera. She's the managing partner of Waithera and Company Advocates, an advocate of the High Court as well, and she is better equipped, I should say, to answer the very few questions I will be asking, so that Kenyans can know what parts of the law or how the law made this happen. So karibu sana wakili, and I think we can just dive right into it.
Yeah.
So Kenyans know that there was some BBI in the air.
Yeah.
It was being championed by His Excellency Uhuru Muigai Kenyatta and His Right Honorable Raila Amolo Odinga.
Correct.
And last week or so, the same kaput.
Yeah.
So they want to know what happened. Why did that have to stop in that fashion? What happened?
Yeah. I think that's a good question and a good one to start. I think most Kenyans did not anticipate this case in court. In fact, most advocates did not know that this case was ongoing. We were all surprised by the judgment because I understand it's been going since way last year.
Yeah.
Because I think some of the documents were filed in December 2020.
Okay.
So the ruling was a surprise to most Kenyans. But
So you're saying most Kenyans caught them by surprise?
caught by surprise because we didn't know Kenyans were so affected that they had moved to court to question the process. So,
Okay.
but the good thing that has come out of this is the conversations it has started.
Yes.
Because now people are discussing more about it. They are very, questioning what is this BBI? Because before it was a document.
Yeah.
Now we're discussing the content, which is a real.
And I think before also it's a given.
Yeah.
This is something that will have to be shoved down our throats.
True.
And it's something that will have to happen because the big boys want it to happen.
I know. And
But right now, it's more like, wait a minute, what is happening here
Yeah.
in the BBI?
Yeah.
What are the contents of this document?
True.
And is it necessary for us to actually have a look at it and see if we can pass it? So the
Yeah.
conversation has kind of changed.
The conversation has shifted.
So however it goes, it was a positive thing.
It was a positive thing, and I think we have to be very objective because Kenyans, let me give an analogy. I
Yeah.
think we are like used to being in a bad relationship with the government, where when we're told to go right, we just go right without questioning. But we are in a new era where we're finding people are questioning the moves of the government. The sovereignty of the people is actually being exercised.
Being invoked. Yeah.
So this case was an amplification of that.
So you're saying the sovereignty of the people, we the people of Kenya,
We the people
has come
we the
alive.
people finally matter. So that's I think that was
That's
the
interesting.
most important thing that came out of this judgment.
All right, so the judgment in itself is not plucked off the skies. It must be founded in sound legal principles
Yeah.
and doctrines
Correct.
for them to say that this BBI was in fact an illegality
Yeah.
ab initio, or
Yeah.
from the start. So maybe help us understand what are these legal principles that made this whole thing come to a halt, because when the president is involved
Yeah.
and when the people's president is involved, then you expect nothing to stand in the way.
Yeah.
But here is a situation where the law actually stood in the way, or supposedly stood in the way.
Yeah.
What are these legal principles or doctrines or provisions
Yeah.
that made this possible?
Good question. I think what happened is the president and his team, the promoters, let me just use that word because that's the word that is being inflamed throughout the judgment.
The promoters.
The promoters
So
of the
BBI had
BBI.
its promoters.
It did have its promoters.
Reminds me of
and
company
the word
law.
promoter is very married to the amendment provisions in the Constitution. So first, let's start from the basics.
Okay.
Yes, we can amend the Constitution. It's provided for under Chapter 16 of our Constitution.
So wait a minute there. So you're saying legally there is provisions within the Kenyan law
Yes.
for us to amend the Constitution.
Correct.
Which provision is that again?
So from Article 255
255
to 257,
to 257.
they give us, very well guidelines on how we can amend the Constitution.
Okay.
The Constitution can be, to put it, we don't want to be very
Yeah,
detailed
don't be
because
technical.
the objective
Yeah,
of
yeah.
this video was to speak
Yeah.
to the masses.
Yeah.
The Constitution can be amended, 1, by the Parliament, or 2, by the people, by the public.
We the people.
We, the people, can amend, the Constitution. So that is Article 257.
Okay.
So what Uhuru, His Excellency, and retired Honorable Raila did.
Is he retired really?
I don't know whether he's retired. He's very active. What he did was they used Article 257 that is supposed to be used by, it's called public initiative. That is the wording of the Constitution.
Public initiative.
Public initiative. So they used that provision to promote the amendment in the Constitution. But the semantics of who promoted really does not matter. I think the whole judgment was really, first of all, who initiated this initiative, this amendment.
Let me ask you, before you go far, in that provision 257, what does it say that should happen as compared to what actually happened?
Okay, so that's a good question. So 257 provides that if the public wants to amend a constitution provision, first of all, there should be a 1 million signature saying that we want to amend the constitution. And then that signature, that's where the IEBC comes in, because they need to verify these registered voters.
So there's going to be 1 million signatures, and then IEBC ought to verify those signatures.
Yes. And then now, what are you promoting for amendment? You need to put it in a draft bill that we are proposing these provisions to be amended. Put that in a bill. Okay. Then now the bill, upon the verification of the signatures, the IBC, upon verification, will take the bill to the county assembly. And then the county assemblies, after they approve it, they'll take it to the National Assembly for another approval. And then now, if it's approved, the president assents it, you can go to a referendum.
But I thought that was what was happening, because a Kenyan who's out there knows that signatures were taken.
Yes.
I think they got to 1 million or thereabout. In fact, more.
Yeah.
Kenyans out there know that bills were being discussed at the county level. So where did they contravene the law?
That is the thing. So the first one is, the semantics, the substance. Who promoted the bill? What does the Constitution say? Constitution says the people. Is the president the people?
Also, it is the originator of the bill.
The originator of the bill is the
first problem.
With the process.
Okay.
If this
so
bill
now
came from you or came from me, then we would be in a different position right now. Then the question would have been, are the provisions that me and you are seeking to amend, can they be amended? Now that brings us to the next question.
No, wait a minute. No, let's go to the first question.
Okay.
So you're saying legally, we went back to the train being stopped.
Yes.
The train was stopped by a number of judges. I'm talking about a Kenyan who doesn't know the law.
Yeah.
It was stopped by a number of judges and the law.
Yes.
Those two things.
Correct.
So of course the number of judges, that's a conversation for another day. But the law now, you're saying the amendment process ought to originate from the people.
Yes.
Pursuant to section 257 of the Constitution.
Yes.
But in this particular instance, that did not originate from the people.
No,
it originated from the president.
Yes.
So in essence, you're saying legally, the president is not part of the people.
Exactly.
Right?
Just to shed some more light. You know how we normally say, we argue in court, that the intentions or the intention of the drafters of the law, because they sat down and they were trying to see loopholes. Section 256 provides for amendment through a parliament. Section 250, Article 256, amendment through a parliament. Article 257, amendment through a public initiative. Clearly, they had an intention of where, if the government wanted to amend the constitution, they can follow the channel of the parliament. And when the people want to amend, they follow the channel of the people. So at what point the government felt that they can come in as one people is what is conflicting to the court.
But one thing is very clear. The president was distinguished from the people under the law and in the constitution.
Yes,
the presidency is different from the people. And initiatives from the president cannot be purported to be initiatives for the people.
True. And I was listening to someone talk on one of these interviews, and he was one of the arguers of the petition, and he was saying the Constitution defines who is a state person, who is a public officer, and who is a person. Those are very different people. You cannot be a public officer and be a person
and being
at
a
the same
state
time.
person.
Yeah, it's not.
All right, fair enough.
Defined.
Fair enough. So let's proceed now. That is the first thing, the law that barred this thing from happening. The second thing?
Now, the second thing was, okay, fine, we can amend the Constitution.
Yeah.
Then the question is, what is the limit of that amendment?
So you're saying even if you want to amend,
Yes.
even if we the people want to amend, there are certain things that can be amended,
Yes.
and there's a certain procedure
That has to be followed.
that has to be followed.
The
So we
procedure.
discussed the procedure, but you're saying there are certain substantive things
Yes.
that are amenable for amendment and others are not.
Yes.
So elaborate.
Now, this is where the confusion is coming in, because there is a doctrine called the basic, and we're not getting legal. There is a basic
Just mention it
structure
legally.
doctrine,
I will try and break it down.
which basically means that the Constitution is set out in a particular structure. For every country, you formulate your Constitution depending on your needs.
Okay.
And if you read the judgment, you'll see the judges went on an extra mile to show us the history of the Kenyan Constitution. And when I say history, let me just highlight the amendments that have been done in previous constitutions, which have been detrimental to the people of Kenya. And so when they were creating the Constitution of 2020, to protect Kenyans from the political elites, they made sure that the amendment clauses were so airtight. So you cannot just come and say, you're going to amend from, the National Assembly is not going to be conducted in this way. The independence of the judiciary is no longer now
people.
Exactly.
Okay.
So that's
you're
structure.
saying the principle is the basic structure principle.
Yeah.
The basic structure doctrine.
Yeah.
So the basic structure doctrine provides that there's got to be a foundation to a constitution.
Yes.
So you cannot purport to want to amend the roof while interfering with the foundation.
Exactly.
Right?
Because the foundation is important.
The foundation is important.
Foundation is
and
the
the
people.
foundation must remain.
Yes.
So you're saying His Excellency Uhuru Kenyatta and Raila Amolo Odinga wanted to amend even the foundation of the constitution, which was not permitted.
Well, I'm not saying, I am just saying the judgment felt, or rather found and ruled that some of the amendments that were being made were,
going
if they
to
were
the root.
effected, they were going to the root of the structure of the Constitution.
Would you be knowing some of those amendments?
Yeah, for example, the issue of the addition of the 70 constituencies.
Addition of the 70
power of
constituencies.
the IBC. It's very clear in the Constitution that should come from the IBC, which
Not
is an independent commission. So when you tell them, do this, and when to do this, and how to do this, you're interfering with their sense of independence.
Okay.
And that is what the
And that
trying to
contravenes the
protect.
Constitution.
Because IBC, you can see, like in future, if we start picking holes on, the power of IBC, and they define our electoral outcomes,
There'll be a problem.
There'll be a problem.
So that's one. Two, what other amendments?
The issue of the Bill of Rights, I can't remember the exact provisions, but the court was very clear, like the sovereignty of the people. For example, the president assuming that there is a public initiative by him, and that is interfering with the sovereignty of the people. That is the power of the people, preserved for them.
For the people.
Should be exercised for them.
But I'm losing you. There was one you say, IBC, addition of constituencies that touches on IBC,
Yes.
and that ought to be the powers of IBC, and
Yes.
it's in contravention with the basic structure of the Constitution. So I'm asking, what forms part of the basic structure of the Constitution?
So from what the court stated, and from the doctrine itself, they are and the history of Kenyans, the Bill of Rights.
Okay.
People actually argued and fought for that to be in our constitution.
Okay.
The right to fair trial. During Moi era, that was not one of our rights. And then the issue of independence of the judiciary, that should be protected and guarded, because we need the checks and balances in our government.
Okay.
The composition of the national
So they were even
Assembly.
interfering with the judiciary. I heard of ombudsman and stuff.
Yeah, they were interfering in the judiciary, because the ombudsman office, what it was supposed to do is become like some sort of a captain or a prefect,
a monitor
to the judiciary. That will curtail the independence.
Okay, so basically the long and the short is you're saying some of the proposed amendments were going to the very spirit
of
the Constitution.
Correct.
And that was not permissible.
That was not permissible.
We said that principle is the basic
structure
doctrine.
Yeah.
So number one, we've established that the first thing was that the process was flawed because it was emanating from the presidency and not the people.
Correct.
Number two, you're saying the amendments proposed in the referendum, in the BBI, were going to the very spirit of the Constitution.
The Constitution, yeah.
So which
the
was
core,
not the core of the Constitution, which was not permissible.
Yes.
But why are you saying so? Wasn't this also now to go to the people themselves to make a determination?
Right. That's the whole again back to the history of our Constitution. Chapter 1 of our Constitution talks about sovereignty of the people. Our Constitution is based on what the people want. In fact, if you look at all the drafts and the review commission, the drafters of our Constitution, all of them went to the people. Every provision that comes that touches Mwananchi in our Constitution came from the people.
Okay.
So if you're going to change it, it should start from the people and not end with the people. And in fact, and it's a good time to mention this, most people and most of us had heard of BBI as a document.
Yeah.
No one spoke about what provisions is this BBI proposing. This Constitution Amendment Bill, what exact provisions are we amending in our Constitution?
Yeah.
There was no that subjective amendment.
Yeah.
It was discussed as a document.
As a document.
To confuse Kenyans to accept a document that they do not know the provisions.
So you would have rather they highlighted Article 5. This is how we're going to amend.
Let Kenyans tell
Article
them.
this, how do we amend this?
Yes.
Article this, how do we amend? But you see, again, I would argue that the people is a very amorphous term. Like nobody here out here is the people.
Yes.
Like there's got to be some people who are actually taking the action. So how would you say that it must emanate from the people, yet the people is not known?
But I think without being academic about it, when you saw the ruling, after the ruling was passed, and people are asked in different constituencies and counties, and even people I've spoken with who are not lawyers, they have no idea what this document is. So you're taking a document for people to vote on and they have no idea of the contents of the document. How then do you expect them to vote? Can you vote on something that you do not know?
No.
And then the Constitution is very clear, Article 33, Article 35, Article 38. 33 on access of information. The people need to be informed before they exercise the Article 38 on voting. So that is a constitutional violation to the people, because you're telling them vote on something that they really have no idea about.
Ladies and gentlemen, we want to take a short commercial break. There's no commercial break here. We do this pro bono, but want to take a small break. We'll be back. We've already understood the two principles, legal principles that have caused this BBI train to screech to a halt, and we'll come back with more on the law and why the law made it possible for the BBI to be halted. Keep it locked.